Hello, everybody. Thanks for joining. Welcome to the Swiss Patent Litigation Fireside Chat. It's the 29th edition already. I skipped the December edition for two reasons. First one being because it was December, no one really has time to join a Fireside Chat in the last week of December. And second reason was there was really not much to report, so it did not really harm to skip December. January, at least at the face of it, was not too busy too. The two decisions that I brought with me today are not decisions of the Federal Patent Court, but rather of the Supreme Court. Two decisions that have been published end of last year. No new decisions published by the Federal Patent Court since then, but that's not an indication that nothing is happening at the Federal Patent Court. In fact, there are things happening. Rumor has it that cases have been settled. I know that an instruction hearing is taking place today. So there are things going on. So there will be things to report soon, most likely next month. But for this edition, I would like to briefly present two decisions of the Supreme Court on appeal against first instance decisions of the Federal Patent Court. So there is a history at the Patent Court in both cases. So the first one is litigation about sun protective agents, and the brand that's at stake here is 𝗨𝗏𝗃𝗏 from STADA. That's sun protection that is not sold in supermarkets, but rather only in drugstores and pharmacies. To give you a brief overview of what happened before, so the Federal Patent Court case had the number 2021, 009, and 010. There is two numbers because two patents were at stake in two nullity cases. I will discuss the patents in a minute. So it were only nullity complaints, no infringement was at stake. And the Supreme Court judgment dates from 14th of December last year. So the first instance judgment held that those patents were invalid for lack of novelty of the higher ranking requests and lack of inventive step for the lower ranking requests. STADA went for an appeal, and that appeal has been dismissed in December. There's a lot of other things going on. EP 105 that had been at stake at the Federal Patent Court and then at the Supreme Court was also under attack in EPO opposition proceedings, but at the EPO, the patentee withdrew his consent to any pending request, so it was effectively a withdrawal of the patent. That happened with a letter of 30th of June last year. But the other patent, EP 127, has also been revoked in first instance proceedings at the EPO by an opposition division. But in that case, an appeal is currently pending. And I need to make a disclaimer notice here. I'm involved in the EPO proceedings with respect to EP 127 on behalf of one of the opponents. So to give you a brief idea of what the patents are all about, it's about a pharmaceutical composition. So it's not just cosmetics here, but by the mere wording of the claims, it's about pharmaceutical compositions. They shall comprise antioxidants, and the same wording in both independent claims of both patents is marked in bold. So focus on the other bits of both claims. The first patent, EP 127, uses language for use in a method for protecting the skin. And the other patent, the 105 patent, uses the language for protecting the skin. Whatever difference that may make, we'll come to that in a minute. And then it's about to protect the skin from damage by infrared radiation, so not just some kind of radiation, but infrared radiation. And the damage is caused by activation of the formation of matrix metalloproteinase 1. So the two patents then essentially differ in that the first patent only states, well, it includes an effective amount of antioxidants, and the other patent spells out a certain group of antioxidants from which the antioxidants are to be selected. So one argument made on appeal by STADA was that the claims are a so-called second medical indication. So it's a literal citation from the Supreme Court decision, which is in German, but I will translate it on the go. So it's a second medical indication claim, and that what is at stake is that the upregulation of this MMP proteinase that is triggered by infrared radiation, and that this is a totally different suffering than the upregulation of the same matrix metalloproteinase by UV radiation. And it had been a surprising finding that, this upregulation also occurs due to infrared radiation. And that was not known from the state of the art, from the prior art. And why is that important? You will get the idea from Supreme Court reasoning in the judgment of December. The Supreme Court held in the first place, well, we don't need to enter into the discussion whether this second medical indication as it is presented is patentable in any event. What matters and what is decisive is that the mere explanation of why an invention works or why a certain effect occurs, that this cannot be a distinguishing feature over the prior art. Entscheidend ist, dass die bloße Erklärung einer Wirkung jedenfalls kein technisches Merkmal ist, das zur Abgrenzung der Erfindung vom Stand der Technik dienen kann. And the Supreme Court then goes on that the mere explanation of why this upregulation can be prevented, that this does not help the case and cannot distinguish over the prior art. And what is important here is the last paragraph on that slide, namely that the first instance, the Federal Patent Court, held that there is no difference between the damage to the skin caused by upregulation due to UV radiation compared to upregulation of the MMP by infrared radiation. So it's either upregulated or it's not upregulated, and it doesn't matter by which radiation it's upregulated. So when you then only add to the claim the wording that this upregulation is caused by, hold on a second, maybe I show that claim again. The damage is caused by the activation of the formation of matrix metalloproteinase. So that was held to be a mere explanation of why the damage to the skin was prevented, and that did not help the case. So moving on to the next case, that is coffee capsules. On the left side, you see a Nespresso capsule of the 𝗿𝗏𝗺 line of products from Nespresso. And on the right side, that's an illustrative barcode with no specific meaning. It's just the barcode, as you know, from any product in a supermarket. When you look at the left side again, on the 𝗿𝗏𝗺 capsule, on the rim of that capsule, there is also a, well, let's call it a pattern of dark and white or silver lines. at least at the face of it, they appear to have not the same width. So there are broader black lines and smaller black lines. So it looks like a pattern, but without knowing what is encoded and how it is encoded, it's hard to tell what it actually is. And that essentially was what that case was all about. Again, to give you a bit of a history of that case, it's litigation between the German company 𝗂𝗄𝗽 system. That's a company in the Krüger group of companies. And the defendant was Nestlé and Nespresso. The first instant judgment of the Federal Patent Court was 2021, 006 and 015. Again, two case numbers, because the first one, the 006, was a simple, straightforward infringement case, and the other one, the 015, was a counterclaim for a compulsory license. This was not even dealt with because the infringement claim was dismissed, but that's the reason for the two case numbers here. So the FPC judgment dates back to May 2023, and it held that there was no infringement of the patents in suit for a very simple and straightforward reason. The claims always require a barcode, and the code on the rim of the Vertuo capsules was a bit code. Supreme Court then, that is case 4A320 of 2023. Supreme Court dismissed 𝗂𝗄𝗽's appeal, so that decision is now final. So it was held that there is no infringement because there is no barcode, but rather a bit code on the Vertuo capsules. So what looks pretty straightforward definitely was not so easy. And then just to mention that there is a lot of other things going on. There are various other proceedings. What I'm aware of are assignment actions, so ownership disputes between 𝗂𝗄𝗽 and Nestlé. That was litigated both in Switzerland and in Germany. The case in Switzerland has been decided in first instance proceedings. Nestlé's complaint was dismissed, so the patents were not held to belong to Nestlé and Nespresso. And to the best of my knowledge, that case is still pending at the Supreme Court. So Nestlé appealed that one too, but I'm not aware of any decision on that yet. Then there is infringement litigation in the US ongoing. There was a summary judgment last year of a district court. I think it was in the Northern District of California, if I'm not mistaken. That court held that, well, due to certain submissions that had been made in EPO opposition proceedings, which had also been filed in the US prosecution as an IDS submission, that actually constituted a waiver of any bit codes. And since the patents required a barcode, a summary judgment was issued because the code on the Vertuo rims was bit code and the claims required a barcode. So a summary judgment was entered because bit codes were held to be waived. That could have been it, but it wasn't. 𝗂𝗄𝗽 appealed to the Court of Appeals of the Federal Circuit, and that was only recently, I think, not yet a month ago or so, that the Court of Appeals actually held, well, that was not so clear as a waiver, and it sent the case back to the Northern District of California to now decide on the merits. So that case is still ongoing, no summary judgment in the US anymore. And there's a lot of EPO oppositions ongoing with Nestlé intervening, and some cases have been stayed in view of the assignment actions pending. So there is a lot of litigation and administrative proceedings at the patent offices going on between both parties. So that was the head note of the judgment of the Federal Patent Court. I just read that quickly. In a civil action governed by the principle of party presentation, Dispositionsmaxime, Verhandlungsmaxime, the court is bound by the parties' shared interpretation of the patent claim. So that was a pretty clear statement in that head note. But is claim interpretation really something that the parties can agree on, or is that a question of law that the court has to decide on ex officio? That was discussed in the appeal proceedings, but in no uncertain terms, the Supreme Court agreed with the head note of the Federal Patent Court. Again, that's a citation from the Supreme Court judgment in German, but you will get the gist. Loosely translated, the Supreme Court held, well, if both parties agree on a certain claim construction for a specific feature, the court has to simply accept that. It's not a task of a court to come up with a controversy about something where the parties don't even have diverging opinions. That's also pretty clear. But what the Supreme Court also made very clear is that this has no bearing on any third party. So this is just an agreement between the two parties litigating in that case, and then the court should not intervene in that common understanding of the parties. But what's the actual scope of protection of the patent with respect to other cases against third parties, there is no saying on that. So no one should be safe or should feel safe by reading the judgment that says, okay, if the parties agree that this or that is a bit code, and no third party should feel safe because that could be held differently when other parties are litigating again and are not in agreement about a certain claim construction of what a barcode is or is not. So then that was actually the major question in my understanding on appeal. So did the parties really agree on what a barcode is and what a barcode is not? The Federal Patent Court held in the judgment, okay, when the parties agree that a bit code is not a barcode, then yeah, so be it. But the question was, had the parties really agreed what a barcode is and what it is not? And here it's important to understand that the Supreme Court is, well, to a large extent bound by the factual assessment of the first instance. And it only looks whether there is some really arbitrary findings that the first instance made. So it's not a de novo assessment of the facts. It's just looking for arbitrariness. And what the Supreme Court said in their reassessment of what the Federal Patent Court held is, well, it's at least nachvollziehbar, comprehensible what the Federal Patent Court reasoned based on the submissions of both parties. Interestingly, 𝗂𝗄𝗽 on appeal argued a different interpretation of what they had submitted in writing, but still the Supreme Court said, well, that's your interpretation now on appeal, but it was not arbitrary for the Federal Patent Court to interpret that in a different way, namely in the way they did, in the way that a bit code is not a barcode. That was not arbitrary for the Federal Patent Court to hold it in that way, nicht geradezu willkürlich. And not even the fact that the representative of 𝗂𝗃 explicitly said in the main hearing that the parties are not in agreement about the definition of a barcode. Apparently, it's if I recall correctly, I've been there, and I think it's really true that he held literally we are not in agreement about the definition of a barcode, but that did not help the argument that the submissions they made before the closure of the file could be interpreted in the way the Federal Patent Court interpreted it. So if there is a learning from that case, then it's maybe be very clear in what you mean, and don't leave room for misinterpretation of what you put in writing. But it's always easy to say that after the fact. But that's learning from that case, maybe in my personal opinion. Moving on to the third bit that I wanted to briefly present, that's a currently ongoing revision of the Swiss Patent Act. That's ongoing since quite a while, since 2019 or so, 1920, something like that. So it has been made quite a lot of progress. There was a first draft by the Federal Council, and then interested circles were invited to present their thoughts on the first draft. There were a lot of thoughts, and a lot of amendments have been made. The most important amendment, quite likely, is that for appeals in patent matters, so appeals on decisions from the Patent Office are not heard by the Federal Administrative Court, as it was in the first draft of the Federal Council. But that has been amended in a way that the Federal Patent Court is now is now foreseen to hear such appeals, which makes perfectly sense, because patent knowledge is at the Federal Patent Court, not at the Administrative Court. So that was just a natural decision to do it that way. But there were a lot of minor things that were still open and were discussed a lot amongst practitioners. It then went into the Council of States, and there a commission of the Council of States, the Science, Education and Culture Committee, SECC, discussed that draft, and then the comments that were made on that draft, and came up with a different proposal. And then it went to the other chamber of the parliament, the National Council, and that chamber has also the very same commission, the Science, Education and Culture Commission, and they also discussed that draft and the first proposal from the Council of States that had been made last year. And what you see on the screen is a press release of the Science, Education and Culture Committee of the National Council after they had discussed the draft Patent Act. And there are three bits essentially that are mentioned in the press release. The first one is that the majority of that commission wants to broaden the grounds of appeal. I will come back to that in a minute, what that means. The press release is fuzzy on that. The second highlighted section is again referring to a majority. It says that the majority wants that third-party appeals should not have suspensive effect in general. unless the court that hears the appeals, which is a federal patent court, would order differently. So it only refers to the court of appeal. That's the second bit. And the third bit refers to the minority. The minority of that commission wanted to have the suspensive effect of third-party appeals, well, essentially as the Council of States had wished to have it. And it explicitly says does not want to limit it any further, nicht stärker einschränken, als der Ständerat beschlossen hat. So that was all not so clear for me, but a few days later we have seen the draft paper, the Fahne, of all the different stages and the committees of the Council of States and the Council, the National Council. I have highlighted the column with the amendments of the National Council in red. You can see that on the far right side on the slide. Apologies that it's so small, but I will explain what you can see there. So directly on the left side from the red column, so the third column from the left side, there is the submission from the Council of States, and the Council of States wanted to have the third paragraph of this article only referring to certain exclusions from patentability, meaning Article 1A, 1B, and 2. So meaning human genes and embryos and all these things are excluded and in those articles of the Patent Act, and only third parties who appeal on the basis of these well, pretty exotic grounds of appeal would have an automatic right to appeal. The third paragraph, according to the Council of States, said if you want to bring other grounds of appeal, then Article 48 of the law on administrative proceedings shall apply for that. So you can bring other grounds of appeal, but only on the basis of Article 48 of the law on administrative proceedings. Now, what does that mean? That Article 48, in a nutshell, says you have to, you need to be specifically affected by that patent, which is quite a hurdle. And in the reddish column on the right, the National Council indeed broadened the grounds of appeal in the second paragraph by adding Articles 50, 57, 58, meaning that all novelty, inventive step, allowability of amendments, and all these common things that are typically challenged in opposition, appeal. All these are now mentioned in paragraph 2, and this means that you don't need to be specifically affected in order to make a typical opposition / appeal against the grant of a patent. That would then mean that in the National Council's opinion, the third paragraph can simply be skipped because there is nothing anymore to mention there. Then the fourth paragraph says that if you want to appeal as a third party, you have a time limit of 4 months after the grant of the patent, which is, yeah, I have no idea why it has to be that short, but yeah, be it as it may. A typical appeal in Switzerland has 30 days. A typical opposition typically has 9 months. In Germany, at the EPO, This is something in between. I don't know. It's just a Swiss approach to the appeal time limit. So we have to be double as quick as typically for an EPO position when appealing against the grant of a Swiss patent. We will do that and we will manage that. That's doable. Then the fifth paragraph, that is on the right column at the very bottom. There is an explicit mentioning of the majority and minority of that committee. The majority wants that third-party appeals have no suspensive effect, and that the patent office or the appeal court, the Federal Patent Court, can order suspensive effect in exceptional cases, ausnahmsweise. So the majority wants it in general to be without any suspensive effect, and the minority says 𝗫𝗫𝗄𝗃 Ständerat, which what in English means exactly as the Council of States had it. That's a bit fuzzy, but apparently that meant they wanted to have the same wording of that paragraph 5, meaning that only appeals according to paragraph 2. That is what is written in that column of the Council of States. It explicitly refers to the appeals according to paragraph 2, not any appeal of a third party, but only the ones of paragraph 2. That made me thinking, well, are there any other appeals than the ones mentioned in paragraph 2? And yes, it may well be that there are other than the ones mentioned in paragraph 2. Just think of a wrongful reinstatement that happened during prosecution. That is definitely not yet mentioned in paragraph 2, but a third party might perhaps challenge that on appeal. And yeah, that would have no suspensive effect if the minority if the minority opinion would enter into law. But it would have no suspensive effect if the majority opinion would enter into law. And there may be other grounds of appeal which are not mentioned in paragraph 2. Maybe if the patent has been granted to the wrong person, if someone feels I'm the one who should own that patent, that might also be challenged on appeal. And well, people might come up with other creative ideas what might be challenged in appeal by a third party that is specifically affected by that patent. So that's essentially the difference between the majority and the minority with respect to paragraph 5. In my personal opinion, the majority opinion is the one that should be followed. Simply no suspensive effect for third-party appeals, for a very simple reason. Us practitioners have to sell this Swiss patent, and the Swiss patent is not without alternatives. People do get patents with effect in Switzerland by a very established way, namely a European patent validated in Switzerland. Proceedings are well established. They are very okay in most cases. Examination is very good at the EPO. It's timely, and there is in no way any suspensive effect when a European patent is granted in Switzerland. So it will be hard to sell a client a Swiss patent if you cannot tell a client, well, you can be sure that there will be no suspensive effect on that patent. because we simply cannot be sure, because we don't know what exceptionally ausnahmsweise means. And it is not that only the Federal Patent Court can order suspensive effect, as the press release says it, but even the Patent Office can order suspensive effect in exceptional cases. So no one knows what the practice of the Patent Office will be to date. If the Patent Office sees an appeal and there is new prior art that has not been considered, a Patent Office might say, oh, it's an exception that we did not see that, so we order suspensive effect. If that is the case, then this is simply not something that I can sell to any client. And there is a lot of other uncertainties that I have to explain to a client when I have to explain the differences between a European patent validated in Switzerland and a Swiss patent that is then examined on the merits. The one is costs. I have no idea how many office action I will see before I proceed to grant in Switzerland. I have a very good idea how that unfolds at the EPO. I have no idea about the suspensive effect, and I have no idea about the quality. I have no reason to doubt that the examiners at the IPI can do examination with a very high standard of quality, but all that has to be up and running, and there need to be granted patents that people can examine in order to really get an idea of the quality. So it will be hard to sell a Swiss patent with the uncertainty of a suspensive effect. I hope that clarifies very soon when that enters into law, maybe by notices from the Federal Patent Court and from the Patent Office about their envisaged practice about suspensive effect. That has to be clarified, otherwise it will be a showstopper for many clients. Now that I mentioned the entry into force, when might that enter into force? My best guess is that if nothing major happens anymore down the road to that draft proposal, then it might enter into force end of this year, maybe early 25, but it's not that far away that we get a Swiss patent that is optionally examined on the merits. So that was pretty much what I brought with me today. I'm a little late, I'm sorry for that, but yeah, I hope you enjoyed it. And if you have any questions after that presentation, please feel free to leave a comment on LinkedIn or drop me a line by email. And I hope to see you next month, as every month on the last Wednesday of the month over noon. Yeah, I hope you enjoyed it, and thanks for joining, and bye-bye.